Hi everyone, my name is Shazia Khan, and today's unit that we'll be doing is Unit 7, which is Business Law. And the learning outcome we'll be doing today is Learning Outcome 4, which is to recommend appropriate legal solutions to resolve areas of dispute. So before we go into Learning Outcome 4, I just want to give you a summary of what we did in the last Learning Outcome session, which was Learning Outcome 3. We looked in Learning Outcome 3 at examining the formation of different types of business organizations. And we looked at the nature and formation of a company, how it's formed, what is the meaning of a company, and why it's so important that a company has to go through Companies House to be registered as a company. We looked at the importance of unincorporated and incorporated legal structures. We looked at what unincorporated legal structures are, who don't have a legal identity from their owners, which means that the owners are legally responsible for the activities of the business. We then went on to look at what incorporated legal structures are, and have a separate legal personality, and this detaches itself from the shareholders, who are the owners, and directors, managers having a separate legal personality means that individuals are not generally liable for the business debts, which is most companies tend to be incorporated because they don't want to be liable for the business debts and their own assets. We then went on to look at, in Learning Outcome 3, the different types of business organizations and legal structures in the UK, how it's so important that you as an individual know what business structure you want to take, and it's a crucial part of a startup of a business. You need to be able to choose your business structure if you want to be a sole trader, which we went through. So there's sole traders, partnerships, companies, and you've got a registered company, which is a limited company. And then we looked at also limited liability partnerships, LLPs, and we looked at the elements of why LLPs are used and what needs to be done if you want to set up an LLP. We then went on to look at the classification of companies and looked at companies on the basis of liabilities. So this could be companies limited by shares, companies limited by guarantee, and unlimited companies. We then went on to look at companies on the basis of members, so where it's one person, companies, private companies, public companies. We then went on to look at companies on the basis of control, so it could be holding and subsidiary companies or associated companies. We then went on to look at Companies House and the digital role of Companies House in international contexts as well. And we looked at the importance of Companies House, why it's so important, why it's a government body that, a department that needs to be used for companies to register companies, and what their function is within England, Wales, Scotland, and Northern Ireland, because it falls within there. And we looked at their major duties for inspecting all the companies, information on the registers and things like that, and why that was so important. We then went on to look at the strategic plan for the company house, which is focusing on registers, services, and people. We looked at starting up a business organisation and why it's important, and we looked at the registration requirements. So, the 7 key factors to creating a business, things like, business ideas, assessing your situation. So, what this will involve. Your business plan's really important. You're researching your business, registering your business as well, what business structure you want to take, be it a partnership or a sole trader. Sort business finances out, any sort of loans you want to take, and get business advice, because you have mentors and you have advisors out there that will be able to help you set up a business. If you want to get a loan from the bank, the banks will provide you a mentor as well. We looked at the registration requirements for starting a business, so registering with HMRC so that your taxes are being paid. Also, the management of a company, We looked at stakeholders and directors, officers and managers and how they would run the company and what their role is. So the first one we looked at was appointment of directors. So what are company directors, what their roles are and why they're so important within a company. And we looked at the elements of them. We looked at articles of associations and looked at ordinary resolution and shareholder resolution and why that's so important. And we looked at the board of directors and the appointment of directors as well. We also looked at the element of executive directors and the letter of appointment. We went on to look at company secretaries and why they are important within a company and why there's a need for company secretaries. We went on to further develop and look at an auditor within a company and why there's a need for auditors. And the whole point of auditors is to conduct review of the financial statements of the company. And it's an independent person who will make an independent report in accordance with the Companies Act 2006. So the regulations are applied under there. We looked at the role of shareholders within the Companies Act 2006 and how effectively the company's financial supporters are the shareholders. We looked at the shareholders can also be directors and the importance of shareholders within a company. We looked at the role of shareholders under Companies Act, you know, why there was a need to have shareholders under Companies Act. And we looked at the application of company law in the type of business organizations and companies, so different types of business organizations. We looked at the element of raising capital and why that is important from like external sources and why there's a need to raise capital. We then went on to look at a number of ways you can raise capitals through equity and through debt. So, you know, you would get a loan now, or if you've got equity, you could get it on the basis of that. We also looked at the elements of liquidation, where this is a formal process of closing a firm down, you know, any sort of issues where the company could can come to an end would be liquidation. We looked at creditors' voluntary liquidation, members' voluntary liquidation, and compulsory liquidation in regards to that. We also looked at the liquidation process, how that would be wound up and how everything would fit into, you know, winding up in regards to that. Also in Learning Outcome 3, we looked at the historical development indicating importance of common law, development of company law, and we also looked at company law today, how it is and how it's implemented. Now we're going to go on to Learning Outcome 4 and look at the elements of Learning Outcome 4, which is to recommend appropriate legal solutions to resolve areas of dispute. So the indicative content, legal solutions, for legal solutions for different types of dispute resolution. So areas for employment, health and safety, equality of pay, claims, compromise and severance agreements, wrongful or unfair dismissal claims, corporate and commercial disputes, breach of contract, contesting a damages claim, dispute between directors, commercial property, commercial lease transactions, real estate and investment properties. So key terminology, legal solutions for different types of dispute resolution. So legal disputes can arise in a wide range of contexts, including things like, you know, civil disputes or business dispute, commercial disputes. And you know, so if a party are unable to resolve their dispute, you know, they would use the process of trying to resolve it through mediation and things, or outside the court or within the court where possible, and that's referred to as alternative dispute resolution. And there are a variety of methods that can be used. like arbitration, mediation, negotiation, and businesses would mediate to resolve the matter. ADR, alternative dispute resolution, which I'll be using as ADR, also can be quicker, less formal, and less expensive than going to court, and can be used in a wide variety of disputes, such as including those related to business, employment, family, and consumer, which we'll be going through. And there are several methods that can be used in regards to the businesses, and businesses will use a form of mediation so that they don't have to go to courts. And the reason behind it is that they don't want the courts costs as well. There's quite a lot of court costs that would resolve in the dispute being going to a higher level, and people don't want that, and businesses especially do not want to pay any sort of higher costs. So they try to resolve it, because in the world of business nowadays, disputes avoidable from disagreements over, like, we'll go through it and you'll understand, disagreements over things like contracts, to conflicts between business partners, problems developing different forms. There are different types of ways to solve disputes, and we mentioned mediation. Businesses disputes can be complicated and in some instances frustrating, often causing stress and uncertainty. So if there's a way of mediating and resolving it outside the courts, there are benefits for businesses to resolve disputes early rather than take them further, because if it's lengthy court battle, there will be higher costs. But if you mediate before, and negotiate with the party, then you minimize the impact of these costs, because the costs would have a negative impact on the employee confidence and productivity. But not only that, the reputation of the organization could be damaged. So if you try to mediate beforehand and solve the problem beforehand, avoid any sort of reputational damage and sustain any sort of goodwill with the party. So it's a good way to resolve the disputes. So the first area of employment that we're going to look at in regards to dispute resolution is the area of issues in the workplace, which are quite popular ones, and this is the area of health and safety, which is again a really important one in regards to try to protect the health and safety of the person within the workplace, because things can escalate over health and safety issues, and you need to be able to protect that. So health and safety conditions in the workplace have to be maintained. So it could be working conditions need to be safe and fair for all employees. This relates to the physical working environment, health and safety policies, protecting employees from unfair dismissal, which we'll go through a little bit later. Working environment could relate to employees being provided with desks at the right height, adjustable chairs, and correct levels of lighting, because it could affect everything. Health and safety policies are put in place to conform the Health and Safety at Work Act 1974. This is the main act that deals with any issues of health and safety in regards to that. And this outlines the responsibilities that both employers and employees have in keeping the workplace environment safe. Includes things such as staff training, safety equipment, including tools and clothing where appropriate, drinking water, toilets and suitable washing facilities, first aid equipment, protecting employees from any sort of unfair dismissal reasons or leaving the company. So you need to make sure that the elements you have in place, the working conditions, are you are meeting the regulations of the working condition and the impact it has on businesses, especially things like working conditions. It would be breaching them. You would you have a responsibility to your employers, because it's a criminal offence as well. Criminal health and safety law imposes duties on employees to ensure that health and safety welfare of employees, such as also people from outside, contractors, visitors, members of the public, that you have an obligation to them. You must identify things in your job that could harm and take steps. You have a responsibility under the law. You must take reasonable care not to put yourself and others at risk. You must follow the training you have been provided with and don't interfere with misuse of anything that employers provided. Cooperate with employees' arrangements for health and safety. It could become a criminal offence. And if you breach the health and safety, this criminal or civil cases are put forward. If someone is injured at work, the employer could be both prosecuted for the state under criminal health and safety law, which could result in them being punished with a fine if they are an individual sent to prison, and sued by the individual for tort of negligence or part of personal injury with the aim of securing compensation. As we mentioned, the primary act is the Health and Safety at Work Act, and that sets out what their general duties are, and the act that employers must ensure that health and safety and welfare of employers are affected by their operations insofar as reasonable, practicable. Various regulations elaborate on this duty, imposing more explicit duties around certain hazards, processes or group of workers. Regulations are supplemented by approved codes of practice and guidance which give practical advice on how to meet general duty. And it could be things like regulations cover a range of things like such as the use of computers, as we mentioned earlier, working with chemicals, lifting operations, manual handling, radiation, personal protective equipment, PPE, and the working environment. So you need to make sure that all this is implemented in, and you are training staff as well in health and safety, making sure that everyone is trained and, you are following the health and safety regulations. The Occupational Health and Safety Act 1985 includes mechanisms for parties in a workplace to deal with the safety and health and safety issues that previously have led to disputes, and the mechanisms are consultation or negotiation between employee and employee representatives, issue of a provisional improvement notice, or seize work provisions. The Act encourages employers to resolve health and safety issues in a spirit of cooperation. So as we mentioned, there are elements of civil and criminal law. The main two agencies for enforcing, regulating and encouraging health and safety in the UK is the Health and Safety Executive, which is the HSE, and the local authorities. Which regulators are responsible for enforcement depends on the location, sector, or the hazard. Other bodies such as fire services, the Office for Nuclear Regulations, ONCR, and the Maritime and Coastline Agencies responsible for enforcing the law in particular sectors or within with certain hazards. So this is in regards to health and safety. The next one we're looking at is dispute resolution, equality of pay, and why we look at equality of pay, why it's so important in regards to, identifying equality of pay. So firstly, it's important to identify the concept of equality of pay. Equality of pay is your entitlement to the same wage as someone doing work of an equal value to you. So the same or broadly similar work as you or work related equivalent value by a job evaluation study. This is often but not exclusively a gender issue. Women are sometimes, paid less than men for doing the same job, and it's not fair because it is part of the law. There are ways you can, find out if you are being paid equally. Things like asking your colleagues or conducting an equal pay questionnaire, checking job ads, in the UK, but not Northern Ireland, any pay secrecy clause and employment contract is overridden if suspect equality of pay or gender, so on grounds of another protected characteristic. It's really, really important. If you're not paid equally, your employer is breaking the law. As we mentioned, the law, previously the issue is with women, but from actors to sportsperson and BBC presenter, equal pay disputes have been dominated in the news since 2017. All UK companies with more than 250 employees are legally required to publish their gender pay gap data, which is really good because, you should be able to identify, why you're doing the same job and getting paid less. Is it because you're a woman? So the key concept of comparison is the Equality Act. Under the Equality Act, terms of contract contains a sex equality as a purpose of equal pay. If you're not being paid equal, your employer is breaking the law, as we mentioned. Claiming for equal pay rights generally allows you to claim up to a maximum of 6 years of loss of earnings. And if you think you ain't being treated fairly, you could talk or write to the employer. So the main legislation that deals with it is the Equality Act 2010. And if you feel like that your work, you are not being treated fairly, there are disputes that go through. People should be paid equally for the job they're doing. It doesn't matter if they are a man or a woman, because then you are discriminating against gender. And if you're, people like to, these equal pay claims can be costly and time consuming. You have to go to the employment tribunal. You have to have for dealing with proceedings. The term equal pay is sometimes misunderstood, by people. There needs to be an actual comparative of opposite gender, and it could be an existing or previous employer. So, these needs to be taken into facts. The whole fact of the Equality Act is to protect the individual who's carrying out the same work. So it could be things like, as we said, work rated as equivalent or like work or work of equal pay. Areas of employment dispute resolution, compromise and severance agreements. So a compromise agreement is a legally binding agreement between a business and an employee under which the employee agrees to settle their potential claims, and in return the employee will agree to pay financial compensation. Sometimes the agreement will include things of benefit, such as an agreed reference letter. An employee can make a claim against a business under both their contract of employment and under statute. And these claims may rise out on recruitment, during employment, or when their employment is terminated. For a compromise agreement to be legally binding, there are a number of conditions that must be met. So firstly, that the agreement must be in writing. Secondly, that the agreement must relate to a particular complaint or particular proceedings. Thirdly, that the employer must have received legal advice from a relevant independent advisor. Fourthly, that the independent advisor must have a current contract of insurance. And fifthly, the employee's advisor must be identified. And sixthly, the agreement must state the conditions relating to the compromise agreements have been satisfied. And then you've got a severance agreement, which is in regards to employment. So many employees do not realize that unless the severance agreement complies with the specific statute requires, it will not be an effective waiver of statutory claims, and in fact only waive the employee's common law claims. An employer may decide to enter into severance agreement to record the terms of the employer's departure and document the waiver of the claims by the employee in return for a severance payment being made by the employer. In order for a severance agreement to be validly waived all of the employee's claims, certain statutory conditions must be met, and these conditions are firstly that the agreement must be in writing, the agreements must relate to a particular complaint or particular proceedings, the employer must have received independent legal advice, as we mentioned earlier as well, and this must be identified. In regards to when we're looking at the compromise agreement against the settlement agreement, the difference between them is that they are literally, there's not much difference between them because they are literally the same thing. The only thing is, prior to 2013, agreements were known as compromise agreements. They were to compromise claims that employees might have. In July 2013, the Enterprise Regulatory Reform Act was introduced, and the name changed from compromise agreement to settlement agreement on the basis that the language used more accurately reflected what the agreements were. They were settlement of claims rather than a compromise of claims. A settlement agreement must relate to a particular complaint or proceeding, so they're often used when there's a dispute between an employer and employee. They're used in situations where a fair disciplinary or termination process is not being followed in order to allow the relationship to come to quick and dignified conclusions. Settlement agreements are often used to avoid employment tribunal situations. Benefits of settlement agreements can be beneficial for both parties. So for the employee, a settlement agreement ensures that, they have the certainty of being compensated for the loss of their job. For the employer, it can mean costly, such as going to court or an employment tribunal. So, there are both ways they are benefiting from that. Another dispute resolution area is wrongful dismissal and wrongful unfair dismissal claims. Whether you are an employee or an employer, dismissing a staff member or being dismissed is never easy and often quite stressful in certain ways. Wrongful dismissal is where an individual is dismissed from his or her employment in breach of the contract. It differs from unfair dismissal in that it's based on contract law. If someone is wrongfully dismissed, they may claim compensation for all financial and other benefits that would have been received had they been dismissed in compliance with the contract. And that could be, for example, had they remained employed until the end of their notice period or until the end of the contract's fixed term. Unfair dismissal under Section 94 of the Employment Rights Act 1996 is all employees have the ability to bring a claim and seek damages for unfair dismissal. For employers starting fresh employment on or after 6th of April 2012, the right not to be unfairly dismissed generally only arises when the employee has been continuously employed for at least 2 years. If a claim for unfair dismissal is brought before the employment tribunal, the tribunal will need to establish whether or not the employee was dismissed and was the employee dismissed for potentially fair reason. Potentially fair reasons for a dismissal could be things like capability, things like conduct, redundancy, retirement, although there's now subject to transitional provisions from effect from April 2011. It could be things like breach of statute or some other substantial reasons. In certain situations, any dismissal will be deemed automatically unfair. These include any dismissal relating to taking leave for family emergencies, taking or seeking to take leave for family reasons, performing a certain health and safety activity. These are some examples that could be part of it. As we mentioned, wrongful dismissal is a dismissal that breaches the employer's contract. So, employers need to be careful that, they are looking at the elements of this because, they need to make sure that they are not wrongfully dismissing or unfairly dismissing someone, because there are remedies available for wrongful dismissal for the individual. If an employer wrongfully dismisses their employee, they will be liable, as we mentioned earlier, to pay damages to put them back in the position they would have been if the contract had been terminated. Therefore, damages will reflect the net value of wages. The damages recoverable in an employment tribunal for wrongful dismissal is capped at a statutory maximum of £25,000. However, if the value of employees' claim is worth more, there's no such cap in civil courts, and they could pursue their claim there. So, it's very, no matter how long an employee has worked in your organization, it's really important that you document the dismissal process, to help you avoid any sort of claims of wrongful or unfair dismissal. What is the difference between unfair and wrongful dismissal, which we looked at a little bit earlier as well? The following: wrongful dismissal gives rise to a common law action for breach of contract that can be pursued in civil claims or employment tribunal, whereas unfair dismissal is statutory claim only which can be brought in employment tribunal. So we've had a look at that earlier as well. Corporate and commercial disputes, and what are they? So commercial disputes are disputes in a commercial context between two business entities. Commercial disputes may vary in size, scope, and complexity, and include the following types of claims, such as things as antitrust, breach of contract, breach of fiduciary duty. It could be things like fraud, intellectual property, privacy, product liability. It could be things like real estate and shareholding disputes. Commercial disputes are frequently resolved through commercial dispute resolution, mediation, or commercial litigation. You know, they're forms of trying to resolve the dispute. Commercial litigation is a general term of referring to litigation in the courts related to business issues. Typically involves two commercial entities which disagree or some part of the business arrangements. One or both parties may file their claim as a lawsuit and rely on the courts to settle the disagreement. Examples of types of claims brought in commercial disputes, as we mentioned, breach of contract, breach of fiduciary duties, fraud. It could be anything like that. So breach of contract. So what are the potential consequences of breaching a commercial contract? So if a breach of contract occurs, whether you are innocent or offending party, it's important you get specialist advice, okay? The potential consequences of contractual breach are varied and depend on a range of factors. The starting point considers the contractual obligations the parties owe to one another. The contractual terms can be agreed orally or in writing, or combination. The core terms are usually expressly agreed, but others can be implied. For example, some terms may be implied where they obviously without them the contract would make no commercial sense. How to resolve a breach of contract. We'll go into that a little bit. The terms of a contract may expressly set out some of all the consequences for the parties in the event of a particular breach. Many commercial contracts will give one or both of the parties the right to terminate the contract if the other party encounters some kind of insolvency event or breaches a particular obligation. Such express rights do not usually prohibit the innocent party from pursuing other forms of legal redress, such as monetary compensation or damages. So how to resolve a breach of contract? So the two main ways are through mediation and litigation. So if you look at it, if you go into business in order to make a living or to provide for yourself and your family, and in due course your retirement, you know, but nobody goes into business to get involved in any sort of disputes or confrontations. So, you know, traditionally commercial disputes are settled by means of litigation, but it's not always involved enormous grief and great costs, both in terms of money, but terms of energy. And now, fortunately, you know, it's the process that's used quite a lot is the issue of mediation, and mediation is widely used an effective method for resolving commercial business disputes. It is a form of alternative dispute resolution, which is ADR, in which a neutral third party known as a mediator assists the parties involved in the dispute to reach a mutually acceptable resolution. Mediation for commercial disputes can be cost effective and time efficient way to resolve the disputes compared to lengthy and potentially ruinous court proceedings. So the mediation process is it has 7 stages. The first one is selection of a mediator. The parties involved in the dispute jointly select a qualified and impartial mediator. The second stage is the initial meeting, where the mediator conducts an initial meeting with each party to understand their perspective, concerns, and the issues. Number 3, the joint sessions, which is the mediator schedules joint sessions where all parties involved in the dispute come together to discuss the issues. And here each party has the opportunity to present their side. And then the fourth stage is private caucuses, where the mediator may hold private caucuses with each party to explore their interests, identify common ground, and propose potential solutions. Number 5, stage 5, is the negotiation and resolution. The mediator guides the negotiation process, helping the parties generate and evaluate potential solutions. Stage 6 is drafting an agreement. So if an agreement is reached, the mediator assists the drafting a formal agreement, settlement agreement that outlines the terms and conditions of the resolution, and typically the agreement is signed by both parties and in making it legally binding. And then stage 7, enforcement. Once the mediation agreement is in place, the parties are responsible for implementing and abiding by its terms. It is necessary legal mechanism and can be used to enforce agreement in the event that either party fails to abide by the terms. It is extremely important to bear in mind that a mediator is not a judge or even an arbitrator. Mediation is not a continuous process, and the mediator will not take sides or agree with any particular point of view. The purpose of mediation is to assist the parties in coming to a resolution that will give anyone everything that they want, but allow them to walk away with a settlement that they can both live with. While mediation is a valuable method for resolving commercial business disputes, it may be not suitable for all situations. Some disputes may require binding arbitration or litigation, so they may need to go to court if mediation fails to produce an agreement, because sometimes in mediation, people won't agree what they want to agree, so they would go to litigation. And in these kind of instances, it's very important to, get legal advice. Mediation is a growing it's growing in popularity at the moment for businesses and commercial setting, as it's not hard to see why you would. There are many benefits of mediation, so things like confidentiality. The mediation proceedings are typically confidential, would protect the business sensitivity, the reputation of the business. Things like flexibility. Mediation allows for creative and flexible solutions that may not be available through litigation. Cost effective, again, saying that it's less expensive than going to court, which we mentioned earlier. It preserves business relationships, so mediation can help preserve ongoing business relationships by fostering any sort of collaboration and communication between the parties. And it's also faster resolution, so it's quicker compared to the court process, which can be often drawn sometimes a period of years. And in regard to the parties, they have more control over the outcome in mediation. Contesting a damage dispute in commercial. So commercial disputes arise on a number of reasons that can range from minor to severe reasons. No business wants to involve a commercial dispute, but sometimes arise that can be not resolved. It could be things, breaches of contract, as we mentioned earlier. So the element of it is that, you try to resolve the dispute before it goes any further. Dispute between directors. So disputes among directors are sadly extremely common. Individuals are often accustomed to being in control of business, and disputes can arise whether due to future strategy, the conduct of another director, or for another number of reasons. Broadly, these disputes break into 3 categories: disputes over strategy and approach over the future of the business, disputes over governance, and disputes over directors' conduct. However, all of these can lead to what can be the largest disputes over the potential removal of appointment of directors. Some of the causes of disputes as well: whether a dispute arises over director's breach of removal, a director to appoint a director. We have disputes, it could arise through common instances or more serious instances. Causes of director disputes. So disputes between company directors in private companies and shareholders no longer agree how to run the company. Things like lack of day-to-day involvement, commonly with smaller businesses, control where one director looks to dominate the running of the company, dividends and money where one of the directors is taking unfair amount of money out of the business, and breach of duties. So the directors are breaching their duties, often use conflict of interest. In absence of gross misconduct, dismissing the director without going through performance management and disciplinary warnings results in the risk of unfair dismissal. Depending on the terms of any director service agreement or employment contract, a wrongful dismissal claim is also a risk. The dishonest director, the position can be different if it is sometimes elements of fraud, embezzling funds, and the steps could be suspend the director from work. You can carry out investigation followed by disciplinary hearing, or decide whether or not to dismiss the director. Unfortunately, the dishonest director may argue that suspension requires a broad resolution. The justification is that he is a director, so the decision falls outside the honest director's individual remit. You need to note that not all under the standard articles of association, you might dismiss and remove director, but the director's shares do not transfer to the remaining shareholders. This means the dismissed director retains his or her shares. So companies with shareholders agree often to avoid this problem if the shareholder agreement provides for automatic transfer or seizing to an employer as a director. Commercial property. So commercial property is known as commercial property is any property that is used for business activities. Refers to buildings, houses, businesses, but can refer to commercial properties are often treated differently than residential property when it comes to small print. Commercial properties can be things like office building, medical centres, housing buildings, farmland, warehouses. You know, it's different elements of commercial buildings. Commercial leases, transactions, commercial leases, form of legally binding contract between a business tenant, your company, and a landlord. This gives you the right to use the property for business or commercial activity for a set period of time. In return, they will pay the landlord. So a commercial lease is put in place if the agents want to rent out a property in regards to, you know, it could be a warehouse or anything like that. Real estate and investment properties. So an investment property is a real estate property purchased with the intention of earning a return on the investment, either through rental income, the future resale of the property, or both. The property may be held by an individual investor. Individual investor can So investment property can be long-term endeavour or short-term investment. With the latter, investors will often engage in flipping, where real estate is bought, remodelled or renovated and sold at a profit with a short time frame. It could be investment property is a property, land or building or part of a building or both held by the owner, by the lessee, in regards to any sort of issues around it. Investment real estate can provide opportunities for financial gains to investors. Owning investment properties can help build wealth, increase income, and help diversify an investment portfolio. Although there are many types of properties in real estate, primarily most properties can be broken down into two classifications, as we mentioned earlier. commercial real estate and residential real estate. The benefits of investing in real estate are numerous and can be very demanding, depending on the goal of the investor. So how much money they want to invest in real estate property can depend on their investors, tolerance, risk tolerance. Some investors invest in real estate to diversify their money. Oops, sorry. So to diversify their money away from the stock market. Other investors want their money invested in physical assets instead of securities such as equities or bonds. And it can be managed well. Investment, there are risks with investment as well. It's not always that you would profit from it, but investment can take a form of a piece of property that is in disrepair, and then you decide to do it up. So, there are different elements of that. So now we've finished learning outcome 4. Okay, and we've looked at learning outcome 1, 2, and 3, and 4 on this module unit. We're looking at learning outcome 4, which looked at the element of trying to look at in regards to the element of appropriate legal solutions to resolve disputes, things like mediation, areas of employment, health and safety. We looked at equality, and we looked at dismissal, severance agreements, commercial properties and commercial disputes, breach in contract, director's position. We looked at dispute resolution, ADR, mediation, how most companies would use that rather than going into litigation. So this is the end of learning outcome 4. These are the references that you can refer to that we've used for learning outcome 4. Things like Lauder's breach of contract, how to resolve disputes, and how to register a company, and also Investopedia on commercial law. There's a link there for an article you can read. Also refer to ebooks and any sort of additional reading on Moodle. If you have any questions around learning outcome 4, just email learnerwork@ukvarsity.co.uk, and submission of assignment to learnerwork@ukvarsity.co.uk, and it's 2 weeks after the completion of the unit. So that we've now completed 4 learning outcomes. The next session we've got in regards to the business law module is that we've done learning outcome 1, 2, 3, and 4, and the next one is the assignment discussion, which is the next session next week. So we'll do the assignment discussion next week. There's also an article for you to read on a guide to contractual interpretation on Moodle for you to have a look at in regards to the business law module. And also the assignment brief is on Moodle as well. If you have any questions, please email learnerwork@ukvarsity.co.uk. Thank you for attending today's session. Thank you.